As Knight ceded 80% of all reinsurance premiums to its Cayman Islands affiliates, most of this reserve credit was attributable to shadow insurance from its Cayman Island captives. And look, you don't have to understand all that. I don't understand it either. But I understand what they're saying is, hey, Judge, on its face, this company isn't qualified to underwrite this bond. And the more you keep digging, the worse it looks. Welcome to Law and Chaos. It's about to be a very bad week for Donald Trump, who has hearings in at least 3 courts, plus the criminal trial in Manhattan for creating false business records to hide the hush money payment to Stormy Daniels in the run-up to the 2016 elections. We have got a lot to cover, so let's get after it. Hey guys, I'm BlueSky, and today I'm all by my lonesome. As I said last week, we're changing things up with the show, and in preparation for that, I'm coming to you on Tuesdays and Fridays for the foreseeable future. Also, there will be more written content as well, so stay tuned. It's a big week in multiple courts for Donald Trump, although he is getting a bit of a break in New York for Passover. I, myself, am not getting a break. I am getting the opposite of that, and I will be hosting Seder for 16 people, which is wonderful, and I love it. But I am recording this on Sunday, which means that whatever crazy shit goes down on Monday is still in the future for me. Voir dire has concluded last week in the false business records case, and they were able to select 12 jurors and 6 alternates. So opening statements are a go on Monday, and also on Monday morning, there will be a hearing before Justice Arthur Engoron on the sufficiency of the bond in this civil fraud trial. I realize that events may well overtake us here, but I think it's pretty unlikely that the judge will rule on that case from the bench, so I'm going to chance it. Remember, Justice Engoron said that Trump and his company needed to disgorge like $350 million in excess profits for all the fraud they had committed, plus interest, which would have pushed it past $500 million to secure a bond. Trump claimed that he needed to front that cash to appeal. That was always bullshit. What he needed was to post a bond so that the state would be guaranteed to get paid if his appeal was unsuccessful. And if he didn't post the bond, the New York Attorney General could begin collecting immediately by seizing his assets. So Trump's lawyers screamed bloody murder that their client couldn't possibly come up with that giant mountain of money, and he would have to sell his buildings at fire sale prices to raise the cash, which, okay, they did have a point there. But then the appeals court cut the bond to $175 million, at which point I assumed he'd get Chubb to write it for him. Chubb is Trump's longtime insurer, and it wrote the $91 million bond in the E. Jean Carroll case. But no, that is not what happened. Instead, this rando billionaire named Don Hinky appeared and offered to have one of his companies underwrite that note for cheap. And so, of course, Trump took Hinky up on it, presumably because Hinky was offering terms that Chubb was not. And look, you get what you pay for, as they say. So the way this went down is that Trump pledged as security a Schwab account, which has $175 million in cash, in it. Let's put a pin in that for a second. There were a lot of problems with this arrangement, chief among them that Hinky's company does not appear to be licensed in the state of New York. And also, it doesn't appear to be adequately capitalized to underwrite the note. And on top of that, the language in the bond agreement appears to guarantee that Trump himself will pay in the event he loses his appeal, not the bond company. And if you think about that for 5 seconds, you know that can't be right because Trump can't be the guarantor on his own bond. So here's what the prosecutors wrote last week. They said, rather than select as the surety a large national insurance company licensed in New York, experienced in underwriting surety bonds, and with policyholder surplus far greater than $175 million, Chubb, defendants chose instead Knight Specialty Insurance Company, a small insurer that is not authorized to write business in New York and thus not regulated by the state's insurance department, had never before written a surety bond in New York or in the prior 2 years in any other jurisdiction, and has a total policyholder surplus of just $138 million, right? So that means the money that they have, irrespective of their liabilities, is just $138 million. And you will note that $138 million is less than $175 million, which is the amount that the state said he'd have to put up. And a surety bond company doesn't have to hand the cash over to the state, as you would if you were like an individual person, but it does actually have to have the cash on hand. And in fact, Under New York insurance law, section 1115, no insurer doing business in the state shall expose itself to any loss on any one risk in an amount exceeding 10% of its surplus to policyholders, right? So in theory, the biggest bond Knight can write is $13.8 million, which is 10% of the shareholder's profit piece, right? Because that's what the law says. You can't have any outstanding risk that's like more than 10% of your profit. So Knight has argued that it has a parent company and the parent company is good for the money and will indemnify any losses through a reinsurance agreement if Trump loses his appeal. But as within the four corners of the bond agreement, the state of New York can't go collect from the parent company if Trump loses. So right there, that's like a pretty glaring defect in this deal. But Knight says that none of that matters because it has access to the cash in Trump's Schwab account. And did you hear the scare quotes? This is where the AG spends most of the arguing time in its brief, trying to convince Justice Engoron to reject the Knight bond. Because the supposed cash in Trump's Schwab account appears to be bonds. And they are not cash and they do fluctuate in value. Yes, okay. They are marketable securities and they're pretty close to cash in the world of finance. But as a technical matter, they're not cash. But more to the point, Trump can move assets into and out of the account without getting Knight's permission under the language of their agreement. And Knight has 2 days to object and demand that the account be trued up to $175 million using substitute assets. And the fact that it has marketable securities in the Schwab account today is irrelevant if Trump can pull those assets out and dump in Truth Social stock or whatever crap he wants to dump in there tomorrow, right? That substantially undercuts Knight's claim that it's good for the cash because it can just go seize Trump's Schwab account if he loses his appeal. If Trump retains control of the underlying assets which secure the bond, he's functionally the guarantor on his own note, and that's not a thing. Here's what the AG said. Nor does it matter to the outcome that under the true-up provision, the trust would be obligated to contribute additional collateral to bring the value back to $175 million if there is a reduction in market value of the collateral. That obligation is nothing more than a promise by the trust, that's Trump's revocable trust, to contribute additional collateral in the future, which the trust may or may not have the funds to do. For this reason, the promise by the trust to true up the collateral is without any legal effect because the trust is effectively acting as its own surety, which is not permitted under well-settled law. Okay, so that's what they said. You can't guarantee your own bond. So long story short, the Attorney General wants Justice Engoron to reject Knight as an appropriate underwriter and tell Trump that he has 7 days to find another company to underwrite this bond. And if you're a paid subscriber at patreon.com/lawandchaospod or on Substack at lawandchaospod.com, you're going to get that long story a little longer and without any ads. And if not, we still love you and we will see you in a minute. And we're back. Okay, before we get back to the show proper, let's thank our wonderful subscribers because it's Tuesday, it's not Monday. But these are the people who support us at patreon.com/lawandchaospod and on Substack at lawandchaospod.com. They get the show ad-free and with bonus content. Without them, we could not do this. So thank you from Substack to Kathleen, Megan, Carolyn, Susan B., Kay Cole, Susan F., Kim, Jordan, Bill, Jack, Rich, Asawai, Dave, LZ, J. Frank, Kush, Lucas, Spencer, Lester, Leon, George, and Kate. And from Patreon, thank you to Just Sonia, Wendy, Reynard, Michael, Nick, Aya, Chris, Shannon, Raymond, ! Jer, Jeff, Andrea, Rebecca, Jodell, Maytree, AP, Mark, Jonathan, Charles, James, TK Duveron, Kim, and Caustic. Okay, let us talk about opening statements on Monday morning because the New York Times is reporting that the first witness will be David Pecker, the former CEO of American Media International. That's the parent company of the National Enquirer. And if you are a normal person, that name probably doesn't mean much to you unless you snicker like you're 12 years old and I don't blame you, so am I. But let's just review for a minute. In 2015, when he was running for office, Trump, Cohen, and Pecker had a meeting where they agreed that the Enquirer would buy up stories that could be damaging to Trump, and the magazine would make sure that those stories never saw the light of day. So that arrangement was known as a catch and kill, and also Pecker agreed to publish damaging stories about Hillary Clinton. Hence that prevailing media narrative that Hillary was about to drop dead from a deadly disease and was too old and feeble to be president, which sounds kind of familiar, no? So the parties agreed that Trump would reimburse Pecker for whatever cash he fronted to protect Trump, and they proceeded under this arrangement for about a year. During that time, AMI paid a woman named Karen McDougal $150,000 for her, quote, life rights by promising that it would give her a regular fitness column at a sister publication. McDougal had had an affair with Trump about a decade earlier. She never did get that column, and she later told her story to Ronan Farrow at The New Yorker. AMI also paid $30,000 to a doorman named Dino Sajudin, who claimed that Trump had fathered an illegitimate child with a cleaner in one of his buildings. That story was pretty clearly false, but it could have been damaging to Trump, so they paid the guy off. It wasn't that much money. All that time, Daniels was kind of in the background, shopping her story around. She'd had a brief sexual encounter with Trump in 2007 at a celebrity golf tournament in Lake Tahoe, where she hoped to get on The Apprentice. And in 2016, she was, hoping to make a few bucks off of a candidate that nobody thought was going to win in November. Now, I have read that Pecker refused to pay Daniels because his lawyers told him it would amount to an illegal contribution to the Trump campaign. I don't know that that's true. I mean, I guess we'll find out the details when he testifies. Maybe you are in the future and you already know this. But for whatever reason, Pecker did the other two deals and he balked on the third deal. And he said, Trump was going to have to figure that shit out on his own. And then for a while, nothing happened. Stormy Daniels was out there and everybody basically ignored her, except that on October 7th, the Access Hollywood tape dropped, at which point Trump's team started to panic about their guy becoming toxic to women. So the last thing they needed was a porn star going on CNN and talking about a post-coital romp with the president where she spanked him with a copy of Forbes magazine while Melania was home with their infant son, particularly since the magazine had a photo of Don Jr. and Ivanka on it. So, 3 days later, Cohen agreed to pay Daniels $130,000 to keep her quiet, right? Very clearly, it was a response to the Access Hollywood tape. It was to preserve Trump's electoral prospects. Now, that didn't stop Trump from floating several different stories about this, among them that he was just doing it to protect Melania. That was always transparently bullshit. I mean, he could have paid Daniels off any time in the prior decade since they'd bumped bits, and he only agreed to do it a month before the election. So, here's how the DA describes that in the statement of facts that accompanied the indictment last year. The parties are anonymized in the document, but I'll use their real names for clarity, except for Trump, who's the defendant. I think that's pretty clear. The defendant directed Cohen to delay making a payment to Daniels as long as possible. He instructed Cohen that if they could delay the payment until after the election, they could avoid paying altogether, because at that point, it would not matter if the story became public. As reflected in emails and text messages between and among Cohen, Daniels' lawyer Keith Davis, and the AMI editor-in-chief, that's David Pecker, Cohen attempted to delay making payment as long as possible. Ultimately, with pressure mounting and the election approaching, the defendant agreed to the payoff and directed Cohen to proceed. Cohen discussed the deal with the defendant and the Trump Organization CFO, Alan Weisselberg. The defendant did not want to make the $130,000 payment himself and asked Cohen and Weisselberg to find a way to make the payment. After discussing various payment options with Weisselberg, Cohen agreed that he would make the payment. Before making the payment, Cohen confirmed with the defendant that defendant would pay him back. And that right there is what prosecutors are going to point to as evidence that this was done with criminal intent to influence the election. Because he only cared about keeping Daniels quiet through Tuesday, November 8, 2016. He didn't care what she said after, because he'd either be president by then or he wouldn't, and he didn't want to waste the cash buying her perpetual silence if he could fob her off with an IOU for a few weeks and then stiff her in December, which is extremely on brand for Donald Trump. Continuing. On or about October 26, shortly after speaking with the defendant on the phone, Cohen opened a bank account in Manhattan in the name of Essential Consultants LLC, a new shell company he had created to effectuate the payment. He then transferred $131,000 from his personal home equity line of credit, HELOC, into that account. On or about October 27, Cohen wired $130,000 from his Essential Consultants LLC account in New York to Davis to suppress Daniels' account. So, okay. Cohen fronts the $130,000 from his HELOC to Daniels in what was very clearly an effort to influence the election. They didn't want her story to come out and gross out women voters. This amounts to an illegal campaign contribution in that it was both undisclosed and that it exceeded the allowable contribution limit by about $127,000, right? It's some minimal amount. You can, I don't know, it's like $2,750 in 2016. So you could contribute $2,750 to the primary and $2,750 to the general, the end, right? And look, Cohen did indeed plead guilty in 2018 to violating campaign finance law, as well as to a whole boatload of tax fraud. But before that happened, in 2017, Cohen was looking to get paid back for the $130,000 he just pulled out of his house. So, okay, there's also the minor matter of the $50,000 he'd paid to a tech guy from Liberty University to rig an online poll. This is like one of my favorite Trump-Cohen stories. Cohen only really actually paid the guy $13,000 plus a single-used boxing glove he claimed had been worn by a prize fighter. But for the purposes of this case, Cohen told Trump that he'd, fronted the whole $50,000 in addition to the $130,000 to Daniels. So he claimed to be out $180,000. But look, if the Trump organization just paid him $180,000 and was like, here, we owe you this money for work performed, he'd owe half of the $180,000 in taxes, and he'd still be $90,000 short. So Trump agreed to pay Cohen $420,000, which is $180,000 times 2, right? Plus another $60,000 on top of that. So after taxes, for all this rigmarole, Cohen nets $30,000. All right, so Trump is charged with 34 felony counts of creating false business records. And that's a weird number. Agree. Here's how it breaks down. Cohen submitted 11 sham invoices to the Trump Organization for legal work that was never performed. The Trump Organization generated 11 checks to Cohen for $13,000 each, signed by Trump or his son, Don Jr. The Trump Organization then created 12 ledger entries saying it had paid for legal work, which again was false. So each of those things counts as one false business records. I don't know why there aren't 12 invoices and 12 checks. Maybe we'll find that out during the trial. Maybe they couldn't, substantiate it, so they didn't charge them. I don't know. The point is, Trump and Cohen laundered this illegal campaign contribution through the business, and they created these false business records with an intent to defraud and cover it up, right? So Trump is going to argue about that. He's going to say there was no intent to defraud. But since the entire structure of this scheme, the whole plussing it up and doubling it, was so that Cohen could tell the IRS in the state of New York that he'd earned $420,000 and owed $210,000 in taxes, and he hadn't earned any of it, I don't anticipate the intent to defraud being particularly problematic to prove. And honestly, look, as an aside, I have never understood why the state didn't charge them long ago with tax fraud, since presumably the Trump Organization claimed that $420,000 in legal expenses and took it off as a business expense. But whatever. I mean, by now the statute of limitations may have expired. I don't know. Whatever. I'm not inside Trump's head. Thank God. Now, normally, false business records would be just a misdemeanor. And in the Patreon bonus, we're going to get into how these got plussed up into felonies. We'll go into it in detail. But essentially, if that record is created with intent to commit another crime or to aid or conceal the commission thereof, it becomes a low-grade felony. So the DA has pointed to 4 potential other crimes to support this escalation to a felony. You have violations of the federal election law, which Cohen did plead guilty to. There are similar violations of New York state election law. There are violations of New York state and federal tax law, which we touched on above, right? Cohen filed a false tax return. And finally, the DA argued that Trump did it as a part of a scheme that caused other people and entities to create their own false records, right? So AMI recorded the catch and kill payments as a promotional expense when they were campaign contributions, or Cohen created the sham LLC to move money to Daniels. Justice Merchan tossed that fourth one, which, okay, I get it. It's a little circular to say you created false business records to make other people create false business records. It's kind of a little hall of mirrors. But the first three have already been approved by the court. That's the tax fraud and the violations of federal and state election law. Importantly, you don't have to be charged with the other crime. You just have to have intended to commit that other crime when you created the false business records. So you can see why the testimony of Cohen, Daniels, and Pecker is going to be really critical here, because they'll be able to corroborate that this was all done to hide the illegal campaign contribution, which undergirds these felony convictions. Okay, let's take a quick break, and we will be right back to discuss that gag order. And we're back. Okay, so that brings us to Tuesday, where Trump's lawyers get to explain to Justice Juan Merchan why he shouldn't hold their client in contempt of court for constantly shit-talking witnesses and jurors in violation of the gag order. And actually, I think we have some expert commentary on this.
The gag order is unconstitutional. You cannot prevent the defendant from attacking the witnesses, from attacking the judge's daughter, if the judge's daughter could be a basis for disqualification.
Oh, Alan Dershowitz. That was obviously everyone's favorite emeritus professor telling abject lies to Sean Hannity's credulous audience. Here on planet Earth, the D.C. Circuit Court has already ruled that a gag order virtually identical to the one in effect here passes constitutional muster. After that court approved it in the election interference case, Justice Merchan more or less copied it wholesale. So Dersh is just, honestly making shit up. Later in the same interview, the professor confused the statute which allows a defendant in a misdemeanor trial to waive his appearance with one that forces a defendant in a felony criminal case to sit his ass in the courtroom for the duration. It's so chutzpah to say, why do I have to be in the courtroom when you've got 18 taxpaying citizens yanked out of their lives for weeks on end? They have to sit there. You have to sit there. Anyway, Justice Merchan imposed a gag order on March 26, ordering Trump to refrain from making or directing others to make public statements about known or reasonably foreseeable witnesses concerning their potential participation in the investigation or in this criminal proceeding, court staff and the prosecutors, excepting DA Alvin Bragg, and any prospective juror or any juror, plus family members of any of those above categories of people. So naturally, Trump reacted by going on a bender, attacking Justice Merchan's daughter, because I guess she wasn't covered, after which the order was expanded on April 1 to cover family members of the judge and the DA. So now the daughter is in. Since then, Trump has shifted mainly to reposting and quoting other people saying stuff that he's barred from saying himself. So he linked about 6 times to a New York Post article calling Michael Cohen a serial perjurer. And he posted a picture of a written denial in 2018 by Stormy Daniels that she'd ever had sex with him. That was before, when she was trying to live up to the hush money agreement that's at the center of this case. She has long since recanted that. So the prosecutors asked for the court to hold Trump in contempt and fine him $1,000 for each of the 3 specific violations. And then Trump's lawyer, Emil Bove, who spent like a decade as a U.S. attorney at the Southern District of New York, actually stood up in court and argued that, I don't know, maybe RTs aren't endorsements, and how is Trump to know that quoting someone else could violate the gag order? Which that went down amazing, of course. So Justice Merchan scheduled the hearing for Tuesday, as this show is dropping, and he put out an order captioned, "Warning, your failure to appear in court may result in your immediate arrest and imprisonment for contempt of court." That was in all caps. But even after that, Trump blasted out to his followers, "They are catching undercover liberal activists lying to the judge in order to get on the Trump jury." There was no link to that. It was attributed to that rancid Fox News shitheel, Jesse Waters, which, of course, the prosecutors pointed out to the court again in a filing on Thursday, noting that it was a direct attack on potential jurors in violation of the gag order. So, look, Justice Merchan is now volcanically angry, and he puts out another order saying, yes, I will take into account the later statements, and did I mention if you don't show up, I'm going to throw you in jail? So then Trump, as is his wont, linked to another Newsmax article on Sunday, this one about Justice Merchan's daughter. And then Saturday night at 11:47 p.m., he posted a video of his former lawyer, Jim Trusty, talking to the dumbest man on Fox News, Brian Kilmeade. I know the competition is stiff, but Kilmeade's got it. Let's play that clip.
First off, before we actually do, let me ask you this. The speed in which this jury's been sat and selected, alternates included, does it bother you if you're working for Trump?
Yeah. Look, I mean, the big danger in this case, with a venue like New York, Manhattan particularly, is you're going to get a bunch of sleepers. You're going to get people that want to be on this jury. They're going to say the right thing to make sure they don't get immediately eliminated from the jury pool, but they're actually very biased. And so time is your helper. You want time to investigate these people, figure out, do they have some social media moments that show their true colors, have time questioning them, and then really doing the comparative exercise of which ones can we live with on the jury, which ones can we not. Picking a jury in 4 days is a pretty quick pace for that much of a high-profile case. That would give me some concern. They don't know enough about all the jurors that are going to be in the box.
It sounds strange to say, but we still don't know exactly what they're charging him with. What are they actually saying that Trump did that warrants a criminal trial?
Aw, maybe if Kilmeade keeps plugging away with his phonics flashcards, he'll be able to read the indictment himself one day. Anyway, yes, this is another attack on the jurors, and the fact that Trump used Trusty as a sock puppet doesn't change that. Also, while we're on the subject, Trump's lawyers filed yet another emergency appeal on Friday trying to halt the trial. They've done it like half a dozen of these already, including one saying that Trump can't get a fair jury in Manhattan. That was rejected, but now he's back saying that they picked a jury too fast and due process something. I assume by the time you hear this show, the appeals court will have tossed this emergency appeal the way it tossed all the others. But just, while we're on the subject. More to the point, though, Trump keeps violating the gag order. And clearly he thinks that the only thing is going to happen is a slap on the wrist. And, okay, fines of $1,000 a pop are functionally nothing for a billionaire. But those fines can escalate a lot and quickly once the contempt train leaves the station, particularly if they double, so the one violation is 1 and then the next violation is 2 and the next violation is 4 and soon, that's a lot of money. So let's see what happens here. And finally on Thursday, Trump's lawyers will argue about his magical, eternal, executive presidential immunity claim before the Supreme Court. We're going to break it down on Friday in detail, hopefully under the new show format. And there are some filings due in the Florida documents case as well. Suffice it to say that Trump is going to be pretty stressed out this week. And look, he was already pretty unhinged during jury selection, or at least the parts of it that he managed to stay awake for. So Rolling Stone had an interesting quote from Stephanie Grisham. She's Melania's former chief of staff. She said, "I was actually just thinking this morning about how cold Trump kept complaining to be yesterday." That was in court. He whined a lot about it being cold in there. In his normal world, someone would have jumped up and run, not walked, to get the temperature perfect for him. This entire experience must be beyond uncomfortable for him, not just the fact that it dives into such personal details, but he has absolutely no control for probably the first time since he was a young child. Not only in the White House, but every facet of his life, be it at Mar-a-Lago or Trump Tower or Bedminster, he has a group of people that cater to his every whim. At Mar-a-Lago, people literally stand and applaud him just for walking into the room, and in court, he has to sit there quietly while some people talk about how much they don't like him. I can't imagine how hard it has been for him not to get up and storm out of the place like a 5-year-old. Look, I am not pressed about a septuagenarian monster not having control of the thermostat. I mean, ideally, he'd be in a place where he never got to control the thermostat again en route to a place that's perpetually very, very hot. But it is an interesting perspective on what promises to be a wild, wild week. So that's it for us today. It's a bit of a short show. If you are celebrating Passover, Chag Sameach, and don't forget to eat a lot of fiber. And I am very excited for big changes to come later this week. So I really appreciate you guys being here. Thank you, and I will talk to you in a couple of days.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Up to Media, LLC, all rights reserved.